The Supreme Court has refused to stay the entire Waqf Amendment Act 2025 but has put some provisions on hold, including that a person must have been a practicing Muslim for 5 years to create a Waqf. A bench of Chief Justice B.R. Gavai and Augustine George Massey have interfered, put on hold. It said the provision will be stayed till the rules are framed on determining whether a person is a practitioner of Islam or not. Without any such rule or mechanism, the provision will lead to an arbitrary exercise of power, the court said, according to a report by the bar and the bench. Another provision of the Waqf Act, which empowered a collector to determine whether a property declared as a Waqf is government property and pass orders, has also been stayed. The top court said that the collector cannot be permitted to adjudicate rights of personal citizens, and this will violate the separation of powers. While it did not stay the provision permitting the nomination of non-Muslim members to Waqf boards, the top court observed that as far as possible, ex-officio members of the boards shall be Muslims. The court further noted that the Central Waqf Council should not have more than 4 Muslim members, and while state Waqf boards should not include more than 3. The top court, however, denied staying the requirement for the registration of Waqf properties, noting that this aspect was there in the earlier laws as well. I quote, "We have held registration existed since 1995 to 2013 and again now. Pronouncing an interim order, we have considered prima facie challenge to each of the sections and found no case was made out to stay the entire statute." The top court on May 22nd had reserved its order on 3 key issues, including the power to denotify property declared as a Waqf by courts, Waqf by user, or Waqf by deed, which cropped up during the hearing of pleas challenging the validity of the Waqf Amendment Act 2025.